My Lord, this matter was adjourned to this morning, particularly for plea taking and scheduling. And my Lord, we are ready to proceed with the same.
There has been development since then. There's been development since then. Part of the offense, which counsel and
were instructed file and have filed constitutional petition for the Constitutional Court. My Lord, that petition is number 31, 2025. Deals the number of matters, including questions of recusal, questions of referral, to the Constitutional Court. My Lord, questions of the continuation of the criminal trial in this criminal session case. My Lord, the declarations sought in that petition would impact this session case, therefore it is imperative that those matters be disposed of first. Or in preference for this case. My Lord, in addition to the petition, we were also instructed and have filed a formal application which before this honorable court, application is number 814, 2025. in which We are seeking for orders, stay, this court to stay the hearing of criminal session case 335 2025 pending resolution of constitutional petition number 31 of 2025. My Lord, the application has not been formally served yet, but we expect to be able to do so today once the court endorses same. My Lord, it is our submission that that application be disposed of before any other proceedings. Session case 335 can take place. My Lord, for purposes of judicious disposal of the application, my prayer is that the same is fixed by you, my Lord, so that we can have it served, had and determined. Have it today, have it determined. Preferably the course of next week. My Lord, the preference when, if the court is pleased to fix the date for hearing, that we come and submit orally for you, my Lord. Receives the application because it had no date. But to serve that I am aware that it has been date, which is also probably there. So it's true that the date is not yet formally colleagues are. My Lord, taking plea is part of the hearing process. That is the commencement phase, part of hearing. So, where you have questions arising about fair hearing, my Lord, they would affect steps which include plea taking. Hence the prayer for disposal of the application passed. My Lord, the respondent will be dealing with 22 paragraphs of an affidavit in support. So, my Lord, I will concede that granting them today, tomorrow, perhaps up to Monday as the very latest, would be adequate time for them to respond. Application is positive. My humble prayer, my Lord, is that court be pleased to fix the application so that the matter can be disposed of next week. And my Lord, and thereafter deal with whatever position arises. My Lord, the prayer for 1 month, way too long. It is too long. The prayer for 1 month, that's my life. Way too long. State within this capacity can respond to timelines I have suggested.
Let me get this clarification. The state will say we can fix application to state to respond within 1 month. That's all.
It's inordinate, no.
It is my Lord, just to add on to the submissions of Council Kalibala, 2 issues. The claim by the Assistant DPP that they are not aware of this application, rather of the application and the petition, is rather disturbing to us. See, yes, it's neither here nor there. My Lord, they seem not to have moved with the technological shift within the judiciary here, the judiciary system. With the digitalization of the justice system in this country, my lord, they are presumed to be aware. By construction, they are aware of this matter. By construction. The application was uploaded on Equimis. It's there, and they know it. With all due respect, it would be imprudent for the assistant DPP and the entire team to appear this morning at 11 to argue out a matter of this magnitude without checking on Equimis. It's imprudent of them. It's routine, my lord, these days. All of us, before we appear before court, we check even last minute, a few microseconds before we enter here, we have to check, is there any new development? And my lord, once there is any document uploaded on the system, all the parties get notifications. And I'm sure if they checked their gadgets, the notifications are there. So that is a lame excuse. As I said, my lord, with all due respect, it's laziness on the part of the assistant DPP. And that shouldn't be used as an excuse to come and pervert the course of justice. That said, my lord, the last issue I wanted to address, my mind too, and the court, is the prayer they are making that despite the fact that there is a pending application for stay, court proceeds to administer retaking. That is the list that would come from the office of the DPP. I think it would be safer on their part, my lord, to first address their mind to the gist of the petition. If a party seeks an order of stay, it's imperative, my lord, that we look at the crux of the matter. In effect, my lord, an application for stay is about arresting the proceedings. And the court is duty-bound to look at the reasons as to why the party is seeking to arrest the proceeding, halt the proceeding, bearing in mind the danger of proceeding in the next step before addressing your mind to the reasons being advanced. So therefore, it goes without saying, since they have not looked at the online application and they have not been physically served, so they don't know the issues that are being raised. And it would therefore be imprudent on their part again to ask to proceed in such a casual manner. My lord, for the emphasis sake, as I conclude, had they taken trouble to look at the online pleadings, I am sure they wouldn't have made that prayer that we proceed, because These are very, very serious issues we are taking to the Constitutional Court. Actually, we have taken to the Constitutional Court. Very, very serious. Going to the root of the proceedings before. Number one, the impartiality of this court. So anything that touches impartiality of the court is so central to the proceedings that court must be sensitive in taking any decision as to whether to proceed or not. The other issue, my lord, with the question of the orders being sought of the removal of a judge. It's a very serious matter. My lord, one needs to first critically reflect on those issues before you proceed to administer the plea. And these are the issues we intend to argue out in the formal application, my lord. And I'm not attempting to argue them out, but I was just emphasizing the point that this is not a matter that should be handled in a cursory manner. Overlook the issues that are being raised and then proceed with the plea taking. I reiterate the prayer made, my lord, that you be pleased, and this is the procedure, my lord, to dispose of the application before you, and the rest will follow. I can support.